three issues emerged. Firstly, the challenge to the legality of this process. Second is the larger implications of this bilateral issue. Third is, what does the future look like? Now the legality part, I am not a law expert, but all naval officers are taught international maritime law. So a little bit I know, but I will not use my knowledge to say what I am trying to say now. It is in the part 15 and annexure 5 and 6, how it is to be resolved is given. It was all talked about a little while earlier. China is a signatory of this convention. So therefore it is binding and the process followed, though China claimed that there were some issues regarding selection of personality, the way it was conducted. I will not go into it, law experts are there, they can always comment on it. So as far as legality is concerned, it is binding on China and it is legal. The larger implications of the bilateral issue, perhaps I do not know, His Excellency, the Ambassador of Philippines is here. He may throw some light on what is happening actually there. But to me it looks like it is under control now. I mean, there is some amicable solution they have found for the time being. So, but look at this. As Anirudh brought out in the morning, the UNCLOS is a package deal. You cannot selectively adhere to something and then forget about the rest. It cannot be done. Just imagine if people do not follow the rules of the road, the marine pollution, and so many of these things are there. If you break this law and follow what is convenient to you, what is going to happen? I'll go back to what I mentioned about the genesis of this. This is not the first time the international law has been broken or rejected. The ruling has been rejected. We have so many historical evidence. 1945, who did it? US. President Henry Truman, what he did, he declared that the entire continental shelf belongs to them, all the resources there. He was under pressure from the business people or, the people who are exploring the sea floor. They had a technology. 46, Argentina did it. 47, Chile and Peru did it. Subsequently, Egypt, so many countries did that. 1957, Indonesia declared that all the 13,000 islands, the water inside that belongs to them. So, as a result of which, US Navy, just sailing the cruiser, Remata, coming from Australia to Singapore, they sailed through these waters to show that we don't listen to all this. So what happened? This resulted in codification of the international law, these kind of incidents. And this also resulted in the famous speech by Ambassador Arvind Pardo, who said that there is common global heritage, the high seas. He talked about that. Global commons, high seas and sharing of resources. Sharing is important, but a more important thing is national prestige, which I don't think we talked about it all this while. This is a very thorny issue. You may forego resources, but you cannot forego your national prestige. So this is one issue for which countries fight, nations fight. Okay, the third issue is how do you look at the future? There are two ways to look at it. One is the dark side. Everything is going to go wrong. Other one is the brighter side. I for one look at the brighter side. Every time there was some problem, something good has emerged out of it. We in India, mythologically have something called a Samudra Manthan, that is churning of the sea. When we churn the sea, first poison comes out, many things, then poison, then the nectar comes out. So I personally believe that something good is going to emerge out of all this chaos. Maybe there is time to look at the law, evolve it further, codify it further as required. Look at the structure of the international organization. This is the time. When is the time to look at it? if somebody creates some problem, this is the time to look at the international organizational structures. Is it all is it called fair? Is there a room to change it? So, with all this as background, we have eminent speakers in our panel. So, I'll invite all of them to share their views, and we'll take on questions after that. Thank you.
Your Excellencies, ladies and gentlemen, good afternoon. I'd like to start off by thanking India Foundation for having me here. It's my really great honor and privilege to be a part of this important event, and I am personally really excited to be in Port Blair for the first time. Today I'd like to focus on the meaning of the obligation to have due regards within one state's EEZ in general. Now I'm speaking of this because the issue concerning EEZ has a lot to do with the South China Sea situation and also the other parts of the oceans. And it is important to clarify the meaning of the rules when you talk about compliance of the rules. So, as you may have know, Article 56, paragraph 1 provides that the coastal states has the sovereign rights over the natural resource and jurisdiction concerning the establishment and use of artificial structures, marine scientific research, and the protection and preservation of the maritime environment. And UNCLOS provides a mutual obligation of both the coastal state and the user state to have due regard to their rights and duties when exercising their rights and freedoms under convention. Because EEZ is a sui generis water created through negotiation of the Third Conference of Law of the Sea, there remains potential conflicts over an excessive use of the area both by the coastal state and the user state. Such excessive use includes, for example, the establishment of no-take zone within EEZ, or the military exercises which interferes local fishery activities, as we will see later. The obligation to have due regard is a rule to consolidate potentially conflicting interests, because ocean is as it was mentioned, is a shareable space, and there could be a multiple uses by multiple users. However, notwithstanding its potential importance, the Convention does not provide the exact definition of this duty. This issue was disputed before the Arbitral Tribunal of South China Sea in 2016, and it is still relevant today in South China Sea as well. So from now on, I'd like to overview the development of this obligation and recent case laws concerning its significance. The primary question that I'd like to deal with is whether any of the states concerned enjoys priority in case of conflict concerning the use of EEZ. There has been three major theories with this regard, and I'd like to briefly explain them in the following section. The first theory claims that user conflicts shall be resolved on a case-by-case basis, founded on an individual balancing of the conflict interests involved. Now, the idea is to promote the wide range of use of the ocean, primarily by the user states. However, this way of standpoint is criticized that it does not sufficiently take into account the evolution, ratio, and practical relevance of the pertinent provisions of the Convention. As it was understood, EEZ is a sui generis zone of which nature is different from high seas. So basically, it's not, a high sea space minus the sovereign rights of the coastal state. The rights incorporated in the EEZ regime cannot be regarded as a congruent reflection of the regime of the high seas. So the preferable idea is that there is a shift of emphasis in favor of the coastal states, and there still remains two standpoints. The first idea is that we presume that a coastal state's use is to be prioritized against the user state. And there's a rebuttable presumption in favor of the coastal states in that point. Some of the UNCLOS provisions indicate that there exists size priority. For instance, Article 60, paragraph 2, provides that the coastal state may establish reasonable safety zones around such artificial islands, and installations and structures in which it may take appropriate measures to ensure the safety of navigation, although the user states have the freedom of navigation under Article 58. But this presumption is rebuttable, and the user states could prove that the coastal states did not act with due regard to its rights or interests. Alternatively, there is a view that there exists a hierarchy of the rights, so that the rights of the coastal states always supersedes that of the user states. Now, the travel preparator of UNCLOS supports the first theory of the rebuttable presumption theory. The text of Article 56 and 58 were fixed at the informal single negotiating text, which was adopted in 1975. And there was no substantial arguments on the meaning of due regards after this text was adopted. However, a prolonged discussion on the conflict resolution between the coastal state and the user state within Z continued throughout the Third Conference of the Law of the Sea. Throughout the discussion, the structural hierarchy among the rights of the coastal state and the user state was rejected during the discussion. I'd like to add that there has been several formulas under the Fourth Geneva Convention on the Law of the Sea, which was adopted in 1958. There were the so-called interest balancing formula, which was provided under Territorial Sea Convention and High Seas Convention, and also there was a no justifiable interference formula that was adopted in Continental Shelf Convention. But none of these formula directly affected the duties, the duties to have due regard under UNCLOS because of the sui generis character of EEZ. And while the Third Conference of the Law of the Sea was going on, the conflict resolution between the rights within the fishery zone has been a significant issue before the international tribunals as well. The most famous case would be the so-called the fisheries jurisdiction case of 1974 before International Court of Justice, ICJ. This was a case where Iceland unilaterally claimed its preferential rights over the area where the United Kingdom was conducting its fisheries. And there was specifically a bilateral agreement between Iceland and United Kingdom dealing with the fishery rights. And the court held that the Iceland's fishery rights was not opposable against the United Kingdom. Then the court held that the principle of reasonable regard for the interests of other states was enshrined in the High Seas Convention of 1958, and so that the Iceland and the United Kingdom has to have due regard to each other's interests and to the interests of other states in those resources. It also held that such states should have due regards to the need of conservation for the benefit of all. Here it seems that Here it seems that the court characterized the interest of the state's parties on an equal footing because it did not hold some presumption in favor of the coastal state. But we should know that the non-absolute nature of the preferential rights should be distinguished from the sovereign rights under EEZ, so that in that sense, this official jurisdiction case has a limited implication towards the interpretation of the duties to have to do regards under UNCLOS. So I'd like to overview the relevant jurisprudence and state practices concerning the duties to have due regards. And here I'd like to strictly distinguish from the case where the coastal states' rights are provided under Article 56, Paragraph 1, and situation where those rights are not provided in the same provision. In the former case, there could be excessive claims by the coastal states or excessive use by the user state. So potentially the excessive use of the coastal states were discussed before the arbitration tribunal for the Chagos Islands case in 2015. Here, so you know that where the Chagos Islands are, and Chagos Islands and Mauritius was part of the UK's United Kingdom's territory, but when Mauritius declared independence, Chagos Islands were left to the United Kingdom, and the United Kingdom established the no-take zone surrounding Chagos Islands, and that affected the traditional fishing rights of Mauritius. And there were specifically a bilateral agreement between the United Kingdom and Mauritius concerning the traditional fishing rights of Mauritius. Now, in the relevant part, the tribunal declined to find the formulation of any universal rule of conduct. So basically, it supported the case-by-case approach. And it held that the extent of the regard that the state has to have required by the convention will depend upon the nature of the rights held by Mauritius, their importance, the extent of the anticipated impairment, the nature and importance of the activities contemplated by the United Kingdom, and the availability of alternative approaches. And then it added that in the majority of cases, this assessment will necessarily involve at least some consultation with the rights-holding states. Then the tribunal went through the process that the United Kingdom established its no-take zone. And in conclusion, it held that the United Kingdom was in violation of the obligation to have due regard because United Kingdom did not appropriately consult with the Mauritius about the establishment of this maritime protection area. But on the other hand, it said that the declaration that it held that in concluding that the declaration of the MPA maritime protection area was not in accordance with the provision of the convention, the tribunal has taken no view on the substantive quality or nature of the MPA or on the importance of environmental protection. So the judgment only held on the procedural aspects, and it avoided its judgment on potentially excessive use of the EEZ. But the importance of this judgment will be that the obligation to consult is usually included under the Article 56, Paragraph 2. Now this has some relevance with regards to the South China Sea arbitration case. As you may have known, it was disputed that China breached its obligation under Article 58, paragraph 3, when it allowed its fishery vessels to conduct fishery within Philippines' exclusive undisputed EEZ. Now, the fact that was upheld by the court was that China, through the operation of its marine surveillance vessels, was aware of, tolerated, and failed to exercise due diligence to prevent such fishing by Chinese flag vessels. And the court said that therefore, China has failed to exhibit due regard for the Philippines' sovereign rights with respect to fisheries and in its exclusive economic zone. And here, the court said that the obligation to have due regards to the coastal states is equivalent to the due diligence to prevent their own vessels. In saying that, it relied on the ITLOS's advisory opinion to Sub-Regional Fisheries Commission in 2015, where the ITLOS also said that the other obligation of flag state, the states are obliged to pay the due diligence to their own vessels. However, this equation should be examined more carefully because it seems that the due diligence to prevent their own vessels may be derived from its obligation as a flag state, not from the obligation to have due regard to the coastal state. So, and I'd like to add that the coastal states' rights, which are not provided in Article 56, paragraph 1, should be distinguished from the discussion that I made in previous section. The typical case would be the military exercises within a foreign EEZ within the consent of the coastal states. And I have to skip the details, but there were previously conflicts between the United States and China concerning these rights. The United States conducts its military surveillance or military operation within the EEZ of China, and China claims that such an activity is violation of Article 56, paragraph 2, because it is excessive, and doing such conduct will be an excessive exercise of its freedom. And in Hainan Islands incidents in 2001, where the U.S. surveillance, the reconnaissance aircraft clashed with the aircraft of China, and the Chinese aircraft was crashed and the crew was passed away. China explicitly protested against such activities, and the similar incidents continued afterwards. Here, I'd like to emphasize that the interest of maritime security is not a part of EEZ regime, and that a proposal to include the security interest into EEZ regime was made during the conference, but it was specifically rejected. So that the claim that China is making towards the military exercises will not be supported by the interpretation of UNCLOS. However, one should also note that the military exercise done without the consent or notification or consultation with the coastal state may interfere the activities enumerated under Article 56, paragraph 1. For example, it could, it could affect the marine environment, or it could affect the fishery activities and so on. So in that case, the arguments concerning the duty to have due regards will be taken care of. So my conclusion would be that the jurisprudence is not yet coherent concerning the theories of the interpretation of this duty. However, the duty to consult and cooperate in good faith is a part of the obligation under Articles 56, paragraph 2 and 58, paragraph 3. Thank you for your attention.
Thank you. May I request now Vijay Shapuraj.
Sorry about this. Once again, allow me to thank the India Foundation for this opportunity to be here. I'm coming to Port Blair after a long time, literally 35 years ago, when I stayed here. And I have a bit of nostalgia about the location of this very hotel. And those two pillboxes that you see here, and probably I've had several times lunch here under the shade of these coconut trees. But then today we have a real estate, a real property here, very pleasant surroundings, and what would be better than this, talking about matters, sea, ocean, and talking about a key word which comes in non-compliance. It's not a very good word. I mean, you always say, you always comply with the orders, and being part of the military, you would say comply. You know, there's also in the Navy, we say comply with my orders, and here is something that I have to talk about, non-compliance. So that's the key word, and we got a geographic space to talk about South China Sea. I think since yesterday we've been talking about this South China Sea. Reams and reams of papers have been written on South China Sea in the last 3 years. At least I can say for in India, we would normally have anything about 300 conferences annually on South China Sea. The subject was very, very important. I mean, it has geopolitical connotations, it has geostrategic issues, there's matters of military, there's talk about environment, but for the first time I'm seeing matters legal being brought in, and that is a different flavor. Maybe the encouragement came after the arbitration was over, that encouraged us to look at these things a little more carefully. I mean, there is something gone amiss somewhere with someone. But then what struck me was this particular citation, and this comes from a book called How Nations Behave. I mean, this is a good reading for, and of course, international scholars of international law, and even practitioners of international law, read this volume called How Nations Behave, and because it's got a lot of legal elements. And for those of us who are in international relations, would always like to read this. And it's fascinating to see almost all nations observe almost all principles of international law, and almost all of their obligations, and almost all the time. I think that's utopia. A state of nirvana, if I may say. I mean, there's nobody does anything wrong. It's perfect. That means the word, I mean, in a sense, are we living in a state in which there will be no faults, no crime, nothing happening at sea? But then, what about compliance? That means there will be all compliance. But then when I look at the word compliance and non-compliance, I see two sides of the same coin. But this coin is not just a flat coin of two sides. I see lots of middle path in it. So it's not a circular flat surface. There are lots of deviations and variations which states will do it. What I thought I'll do is take from here the word all the time. Let me share with you 3 case studies. Very, very interesting case studies. First is about 1986 I'm taking you to. Case concerning the military and paramilitary activities in and against Nicaragua. It's a fascinating case study. And the key word is, US did not appear before the ICJ at the merit stage after refusing to accept the ICJ's jurisdiction. I'm not going to be party to it. The word is, bottom line is, I'm not going to be party to it. Then at the jurisdictional phase of the hearing, however, stated that it relied on an inherent right of collective self-defense, guaranteed in Article 51 of the UN Charter, when it provides. And then the citation goes, upon request, proportionate and appropriate assistance to Costa Rica, Honduras, El Salvador, in response to Nicaragua's act of aggression against these 3 countries. The bottom line is, I will not participate. Let's look at the second case study. Professor Patel this morning brought in a new concept which I'll talk about a little later. Probably we'll have to start thinking in those many terms. But then look at this. This is in July, just 2 months ago. The PCS tribunal awarded compensation to Netherlands euro 5.4 million in damages over seizing of Greenpeace vessel Arctic Sunrise and its crew. Arctic Sunrise, Greenpeace, Sea Shepherd, new sets of institutions, if I may use the word, or organizations who are at play at sea. This morning we talked about private maritime security companies. Then it goes on, 2013 PCA ruled against Russia that it had acted unlawfully after Russian Coast Guard soldiers boarded and took over the vessel without the prior consent of the Netherlands. The boarding of the vessel, arrest, all those things, illegal. Throughout the case, Russian government refused to participate, refused to. So it is not the first instance that we talk about South China Sea. China refused to participate. There have been instances earlier. But are they a pattern, a trend that is growing? I don't think so. You have an isolated set of incidents which are happening. But then does that prevent us from looking at this? Will there be of such trend, of such nature in the future also? Will states be encouraged, small, big part, etc., etc.? Will they be encouraged? The question today is, are we setting a kind of a trend with these? If these are 1 or 2, 3 of them, the third which I talk about, South China Sea, I'm not going to dwell on it because so much has been talked and written about it. But then, we are not going to be participate in this. And in summary, when I looked at these 3 case studies, I came out with some very, very interesting things. Right of collective self-defense, I will not participate. Then we had what Professor Patel this morning talked about, civil disobedience at sea. A new coinage he's given us. We never talked about it. Was there something called as right to liberty at sea? No, I don't think we ever learned in school. Freedom of expression, I thought that was on land. Democracy and a whole lot of things. Then freedom of assembly at sea. But this is now being put together under civil disobedience at sea. A new kind of phenomenon which is happening at sea. Are we prepared for it? But then the question here, not talking about whether this kind of a situation comes in, etc. But the question is participation and compliance, column 2, all the rules. There's a no, no, and a no. Is this the trend? Well, how do we look at this? There are 3 schools of thought on this very subject of compliance and non-compliance. First one, non-compliance chiefly a problem of enforcement. Where is that big brother who's going to say, okay, you're going to do it? Or it's a classroom where the monitor of the class says, okay, you're going to be sitting tight, not making noise. Absence of an overarching authority to punish rule breakers poses challenges. How do we create? After all, we were told in the previous session, sovereignty is at stake. There's nothing beyond sovereignty. Then, but inducements, reciprocity, reputation, and domestic politics and institutions can help to ensure that countries keep their promise under the right conditions by driving up the cost of non-compliance. First school of thought, it tells you, gives you a remedy also. Let's look at the second school of thought. Most non-compliance not as willful. I mean, look at the middle parts. Or calculated act, but rather as a result of capacity problem of poor management. And there it comes in very interesting, and I find this most fascinating. Best part to compliance lies in writing transparent treaties. The question is, are the jurisdiction all right, orders all right? The treaties, are they transparent enough or not? So the problem is not just at the court of justice or court of law. Problem is, are we writing those treaties well? Is there a kind of a, let's say, in the computer now we talk about a copy and paste, okay, bring this, changes here and there, tinker it and it's done. The question is, are we preparing good treaties, brings in kind of robustness in the so-called the argument that we make or a kind of a policy that we follow? The third school. Governments keep their international promises when doing so is consistent with their identity. And yesterday we talked about power and law and power. To my mind, it is paradox of hegemony. A hegemon, if you go back to my comparative, the matrix that I created, it is the hegemon. First was United States, then came Russia, then comes China, the great powers. Again, the power politics, law enforcing power, whole lot of combination comes. So essentially it is a paradox of hegemony. But ladies and gentlemen, all things are not so bad. I mean, sea is still a very pleasant, calm, a lovely place to be in, other than when you are sailing in the monsoons, but it's a lovely place to be in. We have a very fascinating kind of an agreement here, and this is just about last week. Last week, Singapore and Indonesia settling their boundary dispute. Last week, the ambassadors walked up to the United States. Here is us accepting surrender, or surrendering our document that we have accepted the boundary. And look at it, it's been going on from 1973. The blue line, 2009, the green line, and 2014. And last week, then they surrendered. And we've got a clear boundary set. A good example, things are not so bad as one would assume. There's no anarchy at sea. But then this anarchy is now dampened. Let's look at this. I mean, we've had some fascinating discussions in the previous session. A classic, some even suggested, is a martyr. Pragmatism, proactiveness, whole lot of adjectives came about. But then this also brought in, we also discussed issues about gray area. Since the last judgment it came out, how much of homework has been done on those gray areas? Are we going to continue? And why I say this is because it's got to be taken on priority, it's got to be done now. Means now. Because I have a case study of Malaysia and Singapore. 8 years ago, they agreed they're not going to talk about their boundary. And Malaysia goes, finds out 3. Of course, it is very logical and legitimate for Malaysia. They find 3 more documents in the UK archives. And they find that these are in their interest, and they would like to revoke the agreement of 2008 to which they had signed. And for Singapore and Malaysia had agreed to honor and abide by the judgment and had established the MJTC. And it is the MJTC which is a problem today. They have not been able to come out with any kind of concrete result. They have to resolve this issue. So let us not carry what has been done today must be proactively followed and done. Can we bring in a kind of a documentation that we take as a pledge that we will not carry forward this dispute despite the observance or recovery of new kind of an evidence and so on. So we carry, there's a tendency to carry, driven by domestic politics, domestic narrative, change of government. Are all these arbitrations subject to the domestic politics? These are big questions to be answered. Then we have this militaries. My DNA is also military from the Navy. But then, are they part of the problem or are they part of the solution? When Malaysia went into another kind of a appeal for the 2008 judgment, and of course Middle Rock and you got Pedra Branca. Sure enough, you have the ships coming in, carrying out exercises. And then we have a fascinating thing coming from Britain. Britain intending to send a warship to South China Sea in 2018. We have the right, freedom of navigation, and will exercise it. Or was it free? Safety of navigation would have been a better choice. And then it says Royal Navy to deploy aircraft carriers, mind you. New aircraft carrier to specifically to conduct freedom of navigation operations to vindicate our belief in the rule-based international system and in the freedom of navigation through these waters, which are absolutely vital for us. Of course, all waters are important for vitality of international commerce. But then, are the militaries part of the problem or are they part of the solution? Do they need to tone down their rhetoric? I'm not sure on that. I raised this question, the second part of my presentation. What about South China? So much I said, etc. Would China, I raised these questions without getting into the nitty-gritties of it, and I said, would China accept the UNCLOS? No, not really. There's a lot at stake. There's a lot at stake. Does China see high cost of abandoning 1982 law of the sea? Yes. Rely on diplomacy to overcome South China Sea imbroglio? Oh yes. And we've seen that happen. Offer inducement, of course, SOX will be there. It can be resolved, but then that's also SOX when taken separately, that it is an encouragement to suggest that can be resolved the dispute peacefully by peacefully. But then again, intention is being exhibited. Or new status quo, stay committed to law of the sea and abide selectively. And this is where the challenge comes, and that's where I bring in or start something for China, lawfare or legal warfare. And ladies and gentlemen, this comes out from them. Latest maritime maneuver by China is called lawfare. 4 Sh island zones. Sh for Chinese is sand. You got those 4 of them there. The Chinese government seems to be better organized to design and implement clever, the word is clever, legal tactics to defy international norms and impunity. Today there be cleverness. States are supposed to be clever. And when they are clever, they will always be creative, innovative in their making their arguments. So we got South China Sea issue, but we got another issue which is going to, and I'm sure we're going to soon have a conference on this, put in this for sure. Another reams and reams of papers will be written trying to interpret what the Chinese thinking is, what is this Chinese maneuver in terms of legally, or in terms of politics, in terms of geostrategic issues. Finally, I'm going to give a sermon to China, which is not a good story, after all, they're responsible party. China can boost moral authority as global power by exhibiting willingness to resolve matters peacefully. Of course, everybody must say that. And be prepared to accept decision of arbitration. Yes, giving a sermon. But then it has to, they've got their own national interest to talk about. There's a face, there's an image, there's a great power status. Deny that sovereignty disputes do not exist, China risks unfavorable international reputation. Self-explanatory. But the question I raise is, legal imbroglio in South China Sea, is it alarming or not alarming? I do not have the answers. To me, alarming, yes, the regional states, if it is going to be Vietnam, they'll say alarming, what are you talking about? Sitting 3,000 nautical miles away, not so alarming. But then, let's look at the United Kingdom, which is sitting about 9,000 nautical miles, say, I'm going to send my aircraft carrier. The situation is alarming. For him, alarming. Again, how the whole region looks at it. Finally, contending parties may obtain, ladies and gentlemen, this is what we got to watch out for. Contending parties may obtain amenable and acceptable decision, but must be prepared, that states must be prepared, that decisions may not be acceptable to them at a later date, either due to technical issues or due to change in domestic narrative. Let's not underestimate domestic narrative that will drive international law to some extent. Thank you very much for your attention.
Thank you, Vijay. May I request His Excellency the Ambassador of Vietnam?
Vice Admiral Ramakan, Chair of the section, and Excellencies, ladies and gentlemen. First of all, I'd like to thank the India Foundation for organizing this conference, which takes place in Andaman Nicobar, central of Bay of Bengal, and it is a neighbor of South China Sea, and close to our region. And I'd like to thank the organizer for giving me a chance to talk about the imbroglio of South China Sea. Why it is a complicated problem, I think first of all it's a very important region. It is important because of strategic location, because of the natural resources in South China Sea, living and non-living resources, like it is a great big fishing ground and oil and gas, which many countries in South China Sea depend on. And it is, of course, very important trade route, which many countries in the region and outside the region are dependent. But this has been talked a lot, so I don't want to mention here too long. What I want to say here is how we should look at the disputes in this area. In fact, there are two sets of issues, two sets of disputes here. The first is the dispute on the sovereignty of the islands, over the islands in the South China Sea. And the second set is the overlapping of the EEZ among the littoral states. The first set of disputes are mainly related to the two groups of islands. The first group is Parasan in the northern part of South China Sea. And the second group of islands is Spratly Islands, which are disputed by not only between China and Vietnam, but for others claimants. And because of the disputes, so there were some efforts for at least not to expand the dispute in the region by first among by the ASEAN countries in 1992 with the agreement of not to change the status quo in the region. And in 2002, China also joined in a declaration of the Code of Conduct in South China Sea. And China also committed not to change the status quo in South China Sea by joining this agreement. But in fact, the problem is that after signing, China did not or does not even now keep the promise to not to change the status quo. And in 2013, China occupied the Scarborough of the Philippines. So that's the first time change the status quo. And in 2013, China conducted massive land reclamation and built 7 new artificial islands in Spratly Island areas. So this makes the dispute more serious, and it has a lot of implication for the peace, stability, and also the freedom of navigation in the region. Because you know, China also claim the water surrounding the islands that they occupied, and also the artificial that they have built. For this, and the second set of disputes here is overlapping of the EEZ. In fact, there are several overlapping areas among nations in the South China Sea. Not only China, but between Vietnam and Thailand, Vietnam and Cambodia, I think Malaysia, they all have overlapping areas. But these overlapping areas are being settled peacefully by nations in the regions. The only biggest problem is 9-dash line. 9-dash line, which China, when China, you know, they send a map of 9-dash line to United Nations and claim almost 90% of the South China Sea area, and it is overlapping with all the EEZ of the littoral states surrounding the South China Sea. And this 9-dash line, not with this 9-dash line, China not only claim all the islands in this, but all the water inside. And China is also trying to enforce its rights in this area by many activities, such as imposing the fishing ban, like preventing other countries in the region to explore the oil and gas in the EEZ. Against that backdrop, I think the Philippines brought the issue to the Permanent Court of Arbitration. So in 2013, and PCA ruling was came out on 12th July last year. With the two major conclusions, I think two major. One is it rejected the 9-dash line of China. And second is that it said that no structure in South China Sea has status of island. That means it hasn't got any water surrounding of its own. And the PCA ruling gave a very clear explanation of how a country in the region should apply UNCLOS in South China Sea. And it also reduced the disputed areas in the region because it, according to the UNCLOS and the ruling, every country in the region has only 200 miles of EZ and maximum 350 miles of continental shelf. But China, with the 9-dash line, they claim thousands of miles of their EZ and continental shelf. And we think that this is the ruling of the PCA is a very good legal basis for not only China and the Philippines to solve that dispute, but for other countries in the region also. Especially the overlapping areas. But the problem of the UNCLOS, in opinion, and also the PCA ruling is that it has no enforcement power. And the UNCLOS and also the PCA also do not give the full answer of the dispute over the sovereignty of the islands. So this is area I think that the UNCLOS should involve and expand its area of jurisdiction. And I think we should not exclude all the islands and structures in the sea from the UNCLOS, because it's part of the sea and part of the ocean. So this it excluded and it left a lot of disputes. So what is the way forward? I think in overall, the use of force or threat to use of force should first of all be ruled out. And all disputes should be settled by negotiation. So this overall principle must be complied first. Otherwise, if any country bigger trying to bully and trying to threat by the using of force, it will make the problem more serious. And the second, I think finding a solution for all these disputes, the country concerned should comply with what they have committed. In South China Sea, it is DOC. It is the declaration of the Code of Conduct. It has been signed by ASEAN and also China. And the main idea is not to change the status quo. Of course, it has been changed already. But now, if you further change the status quo, it's more problem. And the COC, which is under negotiation, I think I agree with many other article that it should be binding and should be in accordance with the UNCLOS. So we are now waiting for the COC, but the COC must be binding, otherwise it is nothing more than the DOC, which they don't comply. Because there are two set of disputes in South China Sea, so we should have two set of solution for the territorial dispute. I mean, over the islands. There should be both bilateral and multilateral negotiation. The dispute which is concern two parties like Paracels between Vietnam and China, it should be negotiated by both countries. But this but the Spratleys Island, there are 6 parties concerned here. There should be multilateral negotiation. It cannot be as China often insists that it should be between China and each of the claimants. So that's I think that there cannot be only bilateral negotiation here, and the negotiation should be in accordance with the international law and UNCLOS. As regard the overlapping EEZ, I think we can continue to have bilateral and multilateral negotiation, and UNCLOS should be strictly comply with when we are settling this issue. And we also, the most important thing here is how to explain the UNCLOS. The explanation is very, very different among countries here. So we should have explanation in good faith. Yeah. And the PCA ruling recently is very helpful for countries in the region to settle the problem of the EEZ overlapping. And this is also a big problem because of the absence of the enforcement power. We think that the role of collective power of the countries in the region and outside the region are extremely important. I agree that we don't have any enforcement power for the international law, especially UNCLOS. So we also need the diplomacy. We need to make sure that the balance of power is in favor of compliance of the international law and especially the UNCLOS for the issue in the sea. Thank you very much.
Thank you very much. Now we request Mr. Eriksson. He has personal experience of being a judge in the International Tribunal for Law of the Sea. So let's hear his personal experience.
Good afternoon. Can I be heard back there? I can barely see you. Well, our chairman promised that we would try not to speak with legal language, but quite frankly, after 50 years in this business, I'm not sure I can comply with that promise. I must say I was so pleased, Vijay, that you began your presentation with a quotation from Lew Henkin in his book, How Nations Behave. Lew Henkin was my mentor at Columbia Law School, and I refer to him so regularly, month by month. And he's no more, but I still remember him and the things he told us. And one thing, Ambassador Nye, you would share with me, I know, that Professor Henkin said that if you really wanted to know how nations behave in the field of international law, you should look to the activities of legal advisors to Ministries of Foreign Affairs, a position that he and I shared. And little did I know that only 5 years after he told me these things, I would myself be in that very position. Well, Ambassador Karim reminded me of another assertion by Lew Henkin. He said, law is politics. He said, law is politics. And there's no way to get around that. We can speak of the purity of the law, but we know in our national systems and in our international systems, this is a fact. Well, I propose to make my comments in the form of 7 distinct points. And the first, I said 50 years, Mr. Chairman. So in these 50 years or 45 years or so, I have been in what you might say are all 3 branches of international law, of the law of the sea, if we mirror the domestic system. As an executive, in the executive branch, I served for many years in the United Nations in the Secretariat, which helped prepare the way for UNCLOS. In the legislative branch, I served for many years again as representative of my country as we're continuing the negotiations on UNCLOS. And finally, as you just mentioned, in judiciary. So you'll find in me a staunch defender of the law of the sea, of compliance, the necessity of compliance with the law of the sea, and parenthetically, I would challenge the assertions which have been made that international law is not enforceable. And here I can pick up a point again made yesterday by Ambassador Nye and again today, that there are many ways to enforce law other than through force. Well, I must, as my second point, thank the conveners for bringing us together here in Fort Blair. I teach international law and law of the sea in Haryana, which is in the center of North India. And it seems, I must say, a long way from the sea when you're in Haryana. And I feel many of my students don't really appreciate, which was what was said to us last night, that India is a major sea power and is just somewhat not appreciated by the public and certainly not young law students. I try to apprise them otherwise. Well, thirdly, and again I mentioned this last night, 2 of my Japanese colleagues and I had the same thought as we were coming to the conference, and we see all the posters advertising our conference. And you see much of it here with 5 warships. It kind of gives the impression that we are not in the business of international law per se. And I know we're not amongst warmongers. I'm not saying that, of course. But I'm recalling that amongst my other functions is having established an international law program at the United Nations mandated University for Peace. Now there's a very well-known Latin phrase, adage, which in translation says, if you desire peace, prepare for war. Well, University of Peace has transposed this adage and said, if you desire peace, prepare for peace. And I would have welcomed two further pictures on these posters. One, maybe the International Tribunal for the Law of the Sea or some other court. And finally, a classroom, because that is where we will teach students how to abide by the law and give the impression that it is not all so well held that international law is enforceable. Well, my fourth point, which brings me directly to the subject of our presentation today, or of our panel today, that is whether recent developments are eroding the support for the dispute settlement mechanism laid out in UNCLOS, and specifically, most contemporarily, the positions of Russia and China in not participating or choosing not to participate in that dispute settlement mechanism. Well, I'm going to devote my fourth and fifth points to this. The fourth is a purely formal position. UNCLOS does provide for non-participation of parties. And it does it in this way in four particular elements. First of all, there is no provision in UNCLOS for a party, a case falling down when one of the parties is not participate. There is a procedure for the case to continue. And secondly, in international law, in the law of the sea, in International Court of Justice, in ITLOS, in the arbitral tribunals working under Annex 7, there's no provision for default judgments. And thirdly, there's a very specific obligation, which in many ways is shared by some domestic systems, that the court has an obligation under the Law of the Sea Treaty to assure itself of jurisdiction and, moreover, on the merits, both in fact and law, of the claims made. And I'll come back to what that means in practice. And then finally, fourthly, judgments are binding on both parties, and they are final in the sense there is no appeal. They're binding on both parties. Well, my fifth point is, what does this mean in practice? Can it be said that a judgment against a non-appearing party is doomed to fail? Well, there have been a number of instances in international law history, and I'd say two out of maybe 7 of these cases, they resulted in an amicable result, 5 not. Now, one of these cases I must say rather personally involved in, because it involves my own country. Professor Itchie mentioned the case between the United Kingdom and Iceland. Iceland chose not to appear. Now, if we analyze what the prospects are of a case involving a non-appearing party, it is most important, of course, to understand what motivated the party not to appear. And if we analyze the cases, including the ones BJ mentioned, the motivations are very different. I think, I'm not telling any secrets, that in the case of my country, perhaps the main motivation was that we would fail in the case. We were well aware, in fact, that we were pressing the boundaries of international law. Is that fair to say? And it may be true, I won't speculate for the others, but it's a large, important factor, I think. Well, the corollary of that is that the courts do not like non-appearing parties, universally. and they expressed their dissatisfaction in many ways. You understand that a particular onus is placed upon them for the reasons that I just mentioned, their obligation to assure themselves. They have to explore possibilities which the parties themselves would have presented had they attended. The appearing party is often required to argue the case for the opponent. Sometimes it does that upon questioning by the tribunal. And I must say that Philippines discharged the duty which the court in the South China Sea arbitration imposed upon the court by very properly providing all information or possible arguments which could be made and presenting documents for the court to be able to assess those claims. And I think that Philippines should be applauded for that. But nonetheless, it does create a burden for the court. I don't know, many of you who will be familiar with Judge Fitzmaurice's article on non-appearing parties. He had been a judge on the Icelandic case, and he said some rather uncomplimentary things about Iceland. But I guess one of the typically British things that he said, he quoted in his article a limerick in a way of expressing his displeasure. What does he put it? Let me see if I can get it right now. So it's as follows. The rain, it falls on the just and the unjust fellow, but more on the just, because the unjust has stolen the just's umbrella. I think it's clear there's a school of thought which says if you choose not to appear, if you are a sovereign state, if you choose not to appear, well, that is fine, it is your prerogative, you suffer the consequences which I mentioned, and you have to abide by the decision. So following again on what Aniruddha said about what the nature of the law of the sea convention, others have mentioned this. We hear often about the reference to it as the constitution of the oceans. There's another school of thought recently emerged, which says as follows: because the dispute settlement mechanism is such an integral and, by the way, unique part of this all-encompassing treaty, there is an obligation on the parties to the treaty to appear, not to leave it to the court to do its work. So, it is a separate breach of the convention if one doesn't appear. Now, this viewpoint was laid out in a separate opinion in the Arctic Sunrise case by Judges Wolfram and Kelly. And I think this is certainly worth exploring, particularly by someone with my inclination. As I mentioned, I'm a great defender of the law of the sea convention. And I have in fact proposed that this be a subject taken up by the American Society of International Law. So maybe in the next couple of years you'll be able to participate in a panel dealing with that. Well, my sixth and semi-final point. What would have happened had China appeared in the case? Of course, it's absolutely impossible to speculate. Absolutely impossible. But I would like to point to three rather perhaps imperfections in the judgment, in the award of the arbitral tribunal, which might not have been there had there been active participation by China. And again, as I said this morning, the Permanent Court of Arbitration, which provided the registration services. It's an impeccably drafted tribunal, impeccably drafted award, particularly when you deal with the technical aspects of what constitutes an island, other features, low tide elevations, shoals, and so forth. Well, the first one deals with of course, the main issue, which was identified by Ambassador Nye and Ambassador Tansing at the time before, the relevance of the 9-9. I disagree with the tribunal in its rather categorical assertion that all pre-existing claims were extinguished by the entry into force of the convention. What the consequences of that are, it's another story. You will know that the tribunal had a kind of an alternative argument that even if what I just said is true and what they said was wrong, they still maintain that the line was not opposable in international law. The second was on the very nature of rocks. You heard a discussion this morning about that. I disagree with the tribunal in not emphasizing the two very important aspects of the definition or of that article, paragraph 3 of Article 121, that relates to size and geological composition. And thirdly, particularly appropriate when we're here in an archipelagic setting, I think that they were somewhat led astray, the tribunal, in its treatment of the question of whether coastal archipelagos are entitled to the same type of regime as archipelagic states. This is a very detailed point. For those of you who know the law, know what I'm talking about. Well, and finally, as I said, let me emphasize, I don't know what effect some clarification of these three issues would have had on the final award. But I think, again, it expresses the difficulty of course, dealing with the non-appearing party. Well, finally, what about the future? Again, I can refer, as I said, one knows when one is amongst colleagues, when one is agreeing with them constantly. And I again refer to what Ambassador Nye said yesterday about how international law is enforced without military power on a day-to-day basis. And referring again to my mentor, Louis Henkin, he spoke of lateral or horizontal enforcement. So that non-hierarchical status of international law, which again, Ambassador I referred to, does not affect enforcement under these circumstances. So it is only for me only to conclude by hoping that this type of situation, you're experiencing, you called it a breakthrough, Mr. Chairman, will nonetheless sort itself out in perhaps in a way that we discussed earlier, without major confrontation or any further major confrontation, and that the rule of law will prevail in the South China Sea as elsewhere. Thank you.
Thank you very much. I like that. You can enforce law without applying force. Well, I'll not take much time to sum up. So what we'll do is we'll take some questions rather than me summing it up, because you have heard them. So anybody, please. Don't have much time, so maybe just 2-3 questions.
Okay, thank you very much all the speakers for very enlightening presentations. My question, well, it's rather my comment is addressed to Mr. Sakuja's presentation. And firstly, I thought it might be a bit misleading to compare the non-compliance cases by the United States or Russia with what China has done in the case of South China Sea. I don't mean to say that which non-compliance is more serious or malicious, but US and Russia primarily wanted to do is to defend their past actions. And whereas what China has been doing is to sort of defend and justify their ongoing activities to expand their presence and power projection capability in the South China Sea. So that's one thing. And another thing is that the manner, the way China behaved in criticizing the PTI ruling was a challenge to the authority and legitimacy of the UNCLOS. And sometimes it sounded like an insult to the UNCLOS itself. They called it the PTI ruling as a piece of trash. And so in that sense, I thought it's very alarming, not just to countries in the region, but to the international community as a whole, because it challenges the UNCLOS and the global maritime order. So if you have any comment on that.
My question is to Professor Erickson and anybody else who would like to comment too. It's regarding where's the convergence of the Chicago Convention and ADIZ with the UNCLOS, and what implications does it have on the anti-access and area denial strategies of Chinese? So there's a relation between, and to create a de facto exclusion zone, and which is expanding as an expanding core interest of China. So it is much more than UNCLOS. It's a part of a geopolitical strategy, and it's much more than law. So it's a strategy where law, when there is any convention, Chicago conventions or UNCLOS, is being used to further the strategy. So any clarity or any comments, Professor Erickson or anybody else would like to answer this?
Thank you. Yes, thank you. I hope people appreciate the answer I'm about to give in its true spirit. I think you should ask this question at the next panel.
Yeah, would you like to comment?
Well, you raised some very interesting. My purpose was not to compare. That was to tabulate and share with you that there is a trend in terms of non-compliance. I mean, the circumstances are totally different. If you recall, in one of the slides I say, Article 51, that is self-determination. But then in the case of Arctic Sunrise, it's a different story altogether. South China Sea is totally different. But here the trend line is that whether states are willing to comply, and here I find a trend which says they are not willing to comply. For whatever reason, there must be some wisdom under which they find that they need not participate. So there are circumstances in which states will try this participation. Right? And as far as the question about is it alarming or not alarming? Yes, certainly. I still reserved my answer. I said I don't have the answer for that. But then it gives us a kind of a notion of sort that trends in the country of such non-participation would be alarming. Would be alarming.
I'm sorry, we have run out of time. In the next session, we can, they're all related issues, so we can take it up in the next session. The international law is not unlike your sovereignty law. It's based on not on rights and wrong, but it's a relationship. So what was probably acceptable in the beginning of the 20th century is perhaps not acceptable now. I won't use, we have become more civilized, we are civilized then also. But the things have changed. At some point of time, we are fighting with each other to resolve issues. But now we are taking help of all these international organizations to solve our problems. So from that point of view, what China is doing now is worrisome. And also as mentioned that if you look at this particular issue in isolation, it will give a different picture than looking at in a bigger, larger issue. Perhaps China is trying to disrupt the existing the balance of power or world order. These are larger implications. So therefore, people are more worried about the verdict and China's non-compliance with that, rather than being just specific to this one. So with that, I would like to thank my panelists for their lovely presentations. I would also take this opportunity to thank India Foundation for having hosted us here and giving us opportunity to speak our minds. So thank you once again to all you nice audience who had the patience to hear us out.